and make use of continuations to react to the market. That's what you need to learn or know from part 1. Part 2, avoiding IP infringement. This is about risk mitigation and reducing the expense of dealing with patent infringement risk or patent infringement. Often I get a question like this: you developed a product, you're close to market, you haven't done a patent search, you don't know what's out there. What do? We're talking about freedom to operate studies here, what they are, and when you should do them. Importantly, it's a search and analysis of patents to determine the risk of patent infringement for marketing a product or service in the U.S. Important here that FTO and patent infringement is about the commercial product. It has nothing to do, in essence, with your own patents. It's all about what you're selling in the U.S. Okay, why do you do this? Well, you want to know if you infringe a third party's patents. This is practical information. That's the business reason you would do an FTO. There's a legal reason. If you get sued for patent infringement and you're found to infringe and you can't prove the patents are invalid, the judge can say, you know what, you willfully infringed that patent. We're going to triple damages. Well, your freedom to operate opinion can be introduced as evidence to minimize that by a third. So that's the legal reason we would have a freedom to operate opinion. That's reducing damages award. That could be significant. And again, investors want freedom to operate. Investors don't want to buy a lawsuit. Freedom to operate gives you an idea of how to assess that. Okay, this chart is available. I won't go through it, but the idea here is you only have risk of patent infringement when you infringe a patent that is actually valid. So the freedom to operate study is about investigating those two things, infringement and validity separately, okay? Now, just real quick, phase 1 of the FTO, let's say the patent claim has a device comprising a brown widget, a gray gizmo, an actuator, and a controller. You come to me with product A, it has a brown widget, a gray gizmo, a first actuator, and you're like, look, we added a second actuator. I don't infringe a patent. And a controller. Well, actually you do. Product A infringes claim 1 because product A has everything that claim 1 requires. Important, I'm talking about product A. I'm not looking at your patent applications that cover product A. I'm looking at what you're going to make and sell, okay? Well, let's think about what we could do to change it. We're doing a design around analysis here. What can we change? Your engineers come back and says, you know what? Our gizmo doesn't need to be gray, it can be black. So you change it. Right now, product B doesn't infringe. I don't have literal patent infringement there, and I've avoided that patent risk. You wouldn't know that if you hadn't done the FTO study. You wouldn't know that unless you had your counsel look at this issue in some detail, all right? Incidentally, maybe this black gizmo is patentable in and of itself. So you've done a design around of a competitor's patents, and you've identified subject matter that can increase your patent asset, okay? Maybe it's not, maybe changing from gray to black is not that special, but it's worth at least looking at it. The other thing to keep in mind here is that this design around that you may patent, and if you do get a patent for it, is also preventing third parties from adopting that design around, okay? So you are staking out claims to the design arounds that you're doing when you're avoiding patents. Okay, patent litigation, just a big summary. Why FTOs are important is really at the bottom here. $25 million at stake, patent infringement through trial costs you $2.5 million. That's both sides. That's a lot to stomach when you're a plaintiff and you want to go after somebody. But you also have to know the defendant has the same pressure that you will, okay? And this is a tool that you can use. These are some recent statistics from 2017. I'll skip through this. I do want to get through timing. When do you do an FTO study? This is a hard question. I'll be honest. It should be after something that's very basic and conceptual, but it should be before you're about to order millions of dollars worth of components to assemble products, or you have a large capital outlay. All right, or somewhere near you're submitting your products for clinical trial, because you want to know, if I get a product approved that still infringes a patent, that doesn't necessarily help your risk position. So you want to do that sometime ahead. Usually, I'll tell people, if you don't have solid models and you don't have a bill of material, a real bill of material, then a freedom to operate is a little premature. You need to be that sort of technical, that commercially detailed, because you want to have some sense that this is what you're going to make and sell. The other part is when you make substantial product changes. What do substantial product changes mean? It could be different for different companies, but if there's a significant product change, your risk position could change, and you want to assess that. The important thing is to build this into your pipeline, build this into the way that you're innovating your products so that you're addressing these points from time to time. Okay, really this is the last slide, but patentability, I say, obtaining patents. This is about protecting your revenue model. In part one, it's an assessment of the prior art and the publications. Importantly, freedom to operate is about avoiding patents. Focus solely on what you will sell and receive money for. Okay, and with that, I'll open it up.
I know that last slide is really important, so if you want to leave that up while we're talking. What do you do if somebody just doesn't play by the rules? You put a patent, but perhaps just because they're so easily maligned, China sees it and they knock off, and what's your real recourse here?
Well, you've got to have the tools in place to have recourse, number one. If you don't have patent protection, even if you're worried about actors in China, typically they still have to import into the U.S. And under U.S. patent law, if you can prove infringement, you can stop goods at a port. That is pretty significant. No business manager, whether they're in China or in the U.S., wants to deal with their goods being held up at Long Beach. Okay, it's just that's still an option and still available. Yes?
Really great talk, thanks for that. I just had a question about patenting up the food chain, so components and assembly methods and that sort of thing.
Yeah.
I definitely agree with it, but how practically enforceable are those patents? I can see your finished medical device or your molecule, but I can't necessarily see how you got there.
Yeah.
Unless I happen to be in your factory.
Yeah. So there's some generalizations here, but I'll give you, maybe an example. If I have a spinal implant that's made of 3 special polymeric blends, and you blend them together and you put them together in an interesting way. Well, I have probably patent protection for the implant, regardless of what it's made for, regardless of what it's made of. But maybe I can still seek patent protection for these specific polymer blends, okay, as a composition. Now, how do you detect enforcement? That's a challenge for every industry. Often we get information that trickles up from the salespeople and the sales group, and just generally information that comes around. If you get your hands on a sample, we can test it. Part of my job is, when we're drafting these patent claims, is to make sure that we can assess a device. If I have an implant right here, or I have a sample of a polymer blend, that we can send it to a lab, and that report will validate that it infringes the claim. So some of that is just being crafty and thoughtful when you're drafting your patents.
Greg, I want to thank you again for being a sponsor, because as I've shared, there are some folks here in the audience who otherwise might not have been here had it not been for your support. So thank you very much. Greg Grissett.
Thank you.